The duty of the St. Charles County Prosecuting Attorney's Office is to prosecute all violations of the state criminal laws of the state of Missouri that occur within the boundaries of St. Charles County. We routinely work with over 600 commissioned law enforcement officers spread between 11 different departments who routinely patrol our neighborhoods and our commercial areas responding to citizens' complaints of criminal activity. While criminal charges are always brought by the prosecutor's office, we do so in cooperation with law enforcement officers who very often put their own personal safety at risk to put together criminal cases. We also work with victims who find the courage to stand up against their assailants, and we work with all citizens in St. Charles County who come into the courthouse week after week to fulfill their civic duty as jurors, so that standing together, the good people of St. Charles County ensure the safety of all of us. The vast majority of criminal cases begin with a police investigation. Once the investigation has concluded that a crime has been committed and a suspect has been identified, the police will seek an arrest warrant from the prosecutor's office. A criminal suspect may be arrested as much as 24 hours prior to a warrant being issued, or the police may make the arrest after a warrant has been issued. Under no circumstances may the police hold a suspect in jail for more than 24 hours without an arrest warrant. To obtain an arrest warrant, a prosecutor must review the evidence and determine that there is probable cause to find that the suspect committed a crime. Prosecutors use their independent discretion in deciding whether to issue criminal charges. And in addition to reports and interviews, prosecutors review forensic evidence, which may include physical evidence maintained by our police, and it may include scientific evidence such as drug analysis or DNA. In St. Charles County, it is our mission to be diligent, strict, and vigorous with prosecution, but also to always be fair, reasonable, and just. Once a criminal case has been issued, the suspect is designated as the defendant in the criminal court case. As soon as a criminal case is filed with the court, a judge will review a brief statement of the facts of the case and the charges against the defendant and will set a bond. A bond is a means to ensure that a criminal defendant does not flee or avoid court. Should the defendant fail to come to court, he or she will forfeit or owe the court a designated sum. Bond is set in proportion to the severity of the crime, the danger the defendant presents to a victim or to the community, and any indications that the defendant may try to flee. Very soon after a defendant is charged, the defendant will come before a judge in a court, and the judge will explain to the defendant the charges against him or her and the amount of the bond. This is tied to a defendant's Sixth Amendment right to be fully informed of the nature and the charges against him. Before a criminal charge can be submitted to a jury in a trial, evidence of the crime must be first submitted to a judge or a grand jury for consideration. Only after a judge or a grand jury has viewed the evidence firsthand and has found that there is probable cause to support the charges will the case proceed to a guilty plea or a trial. Also, before a case goes to trial, the prosecutor must share his or her evidence and investigation with an attorney for the defendant. This is to allow the defendant the opportunity to fully investigate and prepare any defense to the charges. The Sixth Amendment also guarantees a criminal defendant the right to an attorney. So defendants who cannot afford to hire an attorney will be appointed a well-experienced criminal defense attorney with the Public Defender's Office. It is not unusual for a case to be pending before the court for a period ranging from 6 months to up to 2 years before the case is concluded by a plea or a trial. Defendants who are convicted of serious crimes or who have extensive criminal records will often be sentenced to prison. If a defendant is sentenced to prison, he or she will remain incarcerated until the Department of Corrections finds parole to be lawful and appropriate. Others are placed on a period of probation that may last up to 5 years. During that probation period, a defendant will be supervised by a probation officer who will seek to ensure that the defendant is abiding by the law, gainfully employed, not abusing drugs, and is actively engaged in rehabilitative programs tailored to the defendant's circumstances and the crime that he or she committed. Many understand that the role of a prosecutor is to be an advocate, but a prosecutor has an equally important, though less visible, role as both an officer of the court and a minister of justice. You may see prosecutors asked to comment on very serious criminal cases on news programs or in the media and wonder, why is the prosecutor reserved in his or her comments about the case? This is due to a prosecutor's equally important role in upholding the Constitution of the United States and ensuring that all of those that a prosecutor seeks to convict are first afforded a fully fair trial process, and that jurors who may be called to decide the facts of a case are not prejudiced before the trial even begins. A prosecutor's job is to seek justice, not to merely convict. The prosecutor's office has a lot of power over an individual's life, their liberty, and their reputation. And in the St. Charles County Prosecuting Attorney's Office, we believe that we can best serve our community by guiding our prosecution with a sense of fairness and even humility, as well as thorough, aggressive, fact-driven prosecution. It is our mission to do what is right in every case, every day, to make sure that our neighborhoods are safe and our justice system is fair.